Discovery doctrine. The discovery doctrine, also called a doctrine of discovery, is a concept of public international law expounded by the United States Supreme Court in a series of decisions, most notably Johnson v. McIntosh in 1823. Chief Justice John Marshall explained and applied the way that colonial powers laid claim to lands belonging to foreign sovereign nations during the Age of Discovery. Under it, European Christian governments could lay title to non-European Christian territory on the basis that the colonizers traveled and discovered said territory. The doctrine has been primarily used to support decisions invalidating or ignoring aboriginal possession of land in favor of modern governments, such as in the 2005 case of Sherrill v. Oneida Nation. The 1823 case was the result of collusive lawsuits where land speculators worked together to make claims to achieve a desired result. John Marshall explained the court's reasoning. The decision has been the subject of a number of law review articles and has come under increased scrutiny by modern legal theorists. History. The doctrine of discovery was promulgated by European monarchies in order to legitimize the colonization of lands outside of Europe. Between the mid-15th century and the mid-20th century, this idea allowed European entities to seize lands inhabited by indigenous peoples under the guise of discovering new land. In 1494, the Treaty of Tordesillas declared that only non-Christian lands could be colonized under the doctrine of discovery. In 1792, U.S. Secretary of State Thomas Jefferson claimed that this European doctrine of discovery was international law which was applicable to the new U.S. government as well. The doctrine and its legacy continue to influence American imperialism and treatment of indigenous peoples. Johnson v. McIntosh. The plaintiff Johnson had inherited land originally purchased from the Piankeshaw tribes. Defendant McIntosh claimed the same land, having purchased it under a grant from the United States. It appears that in 1775 members of the Piankeshaw tribe sold certain land in the Indiana Territory. In 1805, the Piankeshaw conveyed much of the same land to William Henry Harrison, governor of the Indiana Territory, thus giving rise to conflicting claims of title. In reviewing whether the courts of the United States should recognize land titles obtained from Native Americans prior to American independence, the court decided that they should not. Chief Justice John Marshall had large real estate holdings that would have been affected if the case were decided in favor of Johnson. Rather than recuse himself from the case, however, the Chief Justice wrote the decision for a unanimous Supreme Court. Decision. United States law. Marshall pointed to the exploration charters given to the explorer John Cabot as proof that other nations had accepted the doctrine. The tribes which occupied the land were, at the moment of discovery, no longer completely sovereign and had no property rights, but rather merely held a right of occupancy. Further, only the discovering nation or its successor could take possession of the land from the natives by conquest or purchase. The doctrine was cited in other cases as well. With Cherokee Nation v. Georgia, it supported the concept that tribes were not independent states, but domestic dependent nations. The decisions in Oliphant v. Suquamish Indian Tribe and Duro v. Riena used the doctrine to prohibit tribes from criminally prosecuting first non-Indians, then Indians who were not a member of the prosecuting tribe. The doctrine has been cited by the U.S. Supreme Court as recently as 2005 in City of Sherrill v. Oneida Indian Nation of New York. Writing for the majority, Ruth Bader Ginsburg stated that under the doctrine of discovery, fee title ownership to the lands occupied by Indians when the colonists arrived became vested in the sovereign, first the discovering European nation and later the original states and the United States. Legal critique. As the Piankeshaw were not party to the litigation, no Indian voices were heard in a case which had and continues to have profound effects on Indian property rights. Professor Blake A. Watson of the University of Dayton School of Law finds Marshall's claim of universal recognition of the doctrine of discovery historically inaccurate. In reviewing the history of European exploration, Marshall did not take note of Spanish Dominican philosopher Francisco de Vitoria's 1532 De Indis nor de jure belli Hispanorum in Barbaros. Vittoria adopted from Thomas Aquinas the Roman law concept of ius gentium, and concluded that the Indians were rightful owners of their property, and that their chiefs validly exercised jurisdiction over their tribes, a position held previously by Palacios Rubios. His defense of American Indians was based on a scholastic understanding of the intrinsic dignity of man, a dignity he found being violated by Spain's policies in the New World. However, the legal scholar Antony Anki has demonstrated, by resisting Spanish incursions, Indians were, according to Vittoria, provoking war with the Spanish invaders, thus justifying Spanish conquest of Indian lands. Marshall also overlooked more recent American experience, specifically Roger Williams's purchase of the Providence plantation. In order to forestall Massachusetts and Plymouth designs on the land, Williams subsequently traveled to England to obtain a patent which referenced the purchase from the natives. The Royal Charter of Rhode Island, issued by Charles Roman II, acknowledged the rights of the Indians to the land. Nor does Justice Marshall seem to have taken note of the policy of the Dutch West India Company. Watson and others, such as Robert Williams Jr., suggest that Marshall misinterpreted the discovery doctrine as giving exclusive right to lands discovered, rather than the exclusive right to treaty with the inhabitants thereof. Contemporary advocacy efforts.